Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 264 in which a issue before the Honorable Bombay High Court was that whether the assessee can go for revision application under section 264 in a case when some intimation under section 143 subsection 1 has been issued to the assessee, and when there is no liability created through that intimation, but after receiving the intimation the assessee comes to know that the assessee has paid some more tax. So whether in that case the assessee can apply for revision under section 264 before the Principal Commissioner of Income Tax. This issue has been taken up by Honorable Bombay High Court in a writ petition in the case of Bahar Infocons Private Limited versus Principal Commissioner of Income Tax and others, and this case is reported in 476 ITR at page number 615, and the date of the judgment is 23rd September 2024. In the present case, when the assessment year 22-23 was there, the assessee realized that due to some excess provision of bonus, the assessee has taken some income two times for the assessment year 1920 to 21-22, and up to that time, the time to file the revised return has elapsed, and after realizing this mistake, the assessee made an application before the learned Principal Commissioner of Income Tax under section 264 that my income has been over-assessed under section 143 subsection 1. So that 143 subsection 1 intimation should be revised up to that extent. The Principal Commissioner of Income Tax was of the considered view that for this type of relief, the proper channel for the assessee was filing the revised return, and on that only ground, the application of the assessee under section 264 was rejected. The assessee filed the writ petition against this rejection because there is no appeal for the order passed under section 264 in the tribunal. When this matter was heard by the Bombay High Court, the court said that in the present case, the revision application was first of all not filed in time, and the court allowed the condonation for that part also and gave its verdict by saying that the role of the Principal Commissioner of Income Tax under section 264 is not restricted to revising only the erroneous orders passed by the lower authorities, but his role also extends in those cases also where the income of the assessee has been over-assessed. Like in the present case, the income of the assessee was over-assessed through the intimation under section 143 subsection 1. The court said that the purpose of section 264 is to give relief to the assessee where the income has been over-assessed. Section 264 can be used where the assessee detects some mistakes that he has been over-assessed. The court said that section 264 is not confined only to the erroneous order passed by the lower authorities. So section 264 can be used to remove a bona fide and genuine mistake on the part of the assessee. The court said that by allowing the revision application in the present case will be a very good step to remove the illegality and injustice caused to the assessee, and if this will not be allowed, then it will cause to injustice and the provisions of the law to be breached. Friends, this is a very welcome case because it has been seen that when the assessee moves some rectification application either before the AO or before the CIT appeal or before the Principal Commissioner of Income Tax through revision under section 264, those applications are generally rejected on the ground that there is no mistake apparent from record, the assessee should file a revised return, they are not decided on merits. So these type of judgments give a real boost to the morale of the assessee, that the assessee do claim justice by using the provisions of section 264 also. at the end of this video. Once again, I am repeating the name of the case. The name of the case is Bahar Infocons Private Limited versus Principal Commissioner of Income Tax and others, and this case is reported in 476 ITR at page number 615, and the matter has been decided by Honorable Bombay High Court in a writ petition on 23rd September 2024. Thank you, friends.